Good morning and welcome. Without further ado, I'm first going to pass to David Jones, who is a faculty member and our Māori Law Students Coordinator.
Kia hiwara ki tēnei tuku, kia hiwara ki tērā tuku, kia tū, kia oho, kia matāra, tihei, mauri ora. Tuatahi rāwe mihi ki tō tātou nei atua, nāna nei tātou katoa I pai here ki raro I te tuanui o tēnei whare I tēnei rā. Nā reira he honore, he krorea ki te atua, he mau ngārongo ki te whenua, he whakaaro pai ki ngā tāngata katoa. Āmine. Kia o tātou ma te huhua o te wā koutou, ko whetūrangi tia haere o ki atu. Kia tātou te kanohi ora tēnā rā tātou katoa. He tika rāme mihi ki te mana whenua kia te ātiawa, tēnei rā te mihi kia koutou, nā koutou te mana whenua o tēnei wāhinei a pipitea. Ka huri anō kia koutou te manuhiri tuārangi kua tae mai ki roto I te kura tātai ture, o wiki tōria tēnei te mihi kia koutou, nau mai, piki mai, kake mai rā. Kake mai rā I runga I ngā āhuatanga o te mātauranga, kake mai rā I runga I te whakatau kia nei, te manu e kai nei te miro, nōna te ngāhere, te manu e kai nei te mātauranga, nōna te ao. Nau mai, piki mai, kake mai, tēnā koutou, tēnā tātou katoa. Ka pine a koe a uki, te pine o te aroha, ki te pine e, kore nei e, waikura e. Kātia ki rā tēnā koutou, tēnā koutou, hui mai tēnā tātou katoa.
Good morning and welcome to the New Zealand Law Foundation Regulatory Reform Conference. We are going to begin with the formidable and shady-looking gentleman in the screen, Dr. Andrew Butler, who is now Chair of the New Zealand Law Foundation Board of Trustees.
Hello one and all. My name's Butler, Chairman of the New Zealand Law Foundation. It's my great pleasure to have the opportunity to make some remarks at the opening of this important conference on recalibrating behaviour, smarter regulation in a global world. The Law Foundation exists primarily to support independent legal thinking, primarily through funding research projects. The projects we support are large and small and cover the whole gamut of legal research topics. While most applications that we receive are generated by the researchers themselves, from time to time the Foundation identifies what it considers to be areas of importance. Regulatory reform was one of those areas. Regulation affects the cost, quality and safety of much of what we do, use and consume in our everyday lives. Regulation is all-pervasive, but can be very challenging to design and implement well. We instigated this project because of our view that a serious and comprehensive review of regulatory models and methods on a multidisciplinary basis, combining the skills, insights and experiences of legal practitioners and legal academics, will be more likely to produce an enduring contribution to this important area of law than funding one-off reviews of particular subfields of regulation. The Foundation was of the view that substantial study on the complex challenges around regulatory reform was long overdue but lacked an obvious funder. The Foundation had the resources and the mandate to bring together relevant academics, economists and practitioners to support their work over a sustained period. As you will know, the Regulatory Reform Project study team includes researchers from Vic's Law Faculty, School of Government and School of Accounting and Commercial Law, working together with research partners from the NZIER and from law firm Chapman Tripp. We are delighted with the way in which they have worked together, challenging and all as it has been from time to time. We hope that their experiences along the way will encourage others to work on some of the big themes that will challenge New Zealand society over the coming years and decades. I've had an opportunity to read a number of the contributions for today's conference. They are, if I may say so, very insightful. I wish you well with proceedings and look forward to seeing some, though unfortunately not all, of you at this evening's dinner. Please, argue and debate hard. These issues are of the utmost importance to our society, and we need to challenge each other and learn from each other as much as we can. Please also, however, at the same time, enjoy the conference. Nā reira, tēnā koutou, tēnā koutou, tēnā koutou katoa.
Now let me introduce Professor Tony Smith, known to many of you, Dean of the Law Faculty.
Thank you, Susie. I am Tony Smith, the PVC and Dean of the Law Faculty here in Wellington, and in that capacity I welcome you all to Wellington, and to those of you who are not from this country, to New Zealand. This conference, Recalibrating Behaviour, Smarter Regulation in a Global World, marks a significant milestone in the life of the research program that began in 2010 with the award of a very large research grant from the New Zealand Law Foundation. It was $1.7 million, and the project, spearheaded by Professor Susie Frenkel, involved a multidisciplinary group of researchers identified in that speech by Dr. Butler. I want to say how very grateful we are in the Law Faculty for the continued support that we have received from the New Zealand Law Foundation and Linda Hagen, who I'm delighted to see, who heads the Law Foundation, is here with us today. We are incredibly grateful for all the support you give us. The New Zealand Law Foundation is the major leading supporter of legal research in New Zealand, and it has over the years made a significant difference to the work of the Law Faculty, and ultimately we like to think to the lives of New Zealanders. The first stage of this regulatory reform project looked at matters such as regulatory certainty and its counterpart discretion, legitimacy in the rule of law, property rights, the policy and processes of regulation, trade and investment, and the trans-Tasman relationship. In 2011, these themes were developed in a book, Learning from the Past, Adapting for the Future, Regulatory Reform in New Zealand. And a product of further work is to be made public with the publication of a second volume, Recalibrating Behaviour, Smarter Regulation in a Global World, which is going to be launched at this conference. Unlike Dr. Butler, I haven't had a chance to look at it yet, but I am particularly looking forward to reading the entry, The Careful Art of Reducing Uncertain Outcomes. I'm sure as a dean I've got a lot to learn from that one. You find the faculty in good heart here in Wellington. We know that we're very fortunate to occupy the fabulous building in the heart of Wellington, and legal Wellington at that, and we're pleased to be sharing it with you for the duration of this conference. Unfortunately for me, Tuesday is the day on which the senior management team of the university has its morning meeting starting at 9 o'clock. I have to head off there now. Like Dr. Butler, I wish you all well in your deliberations today and tomorrow. I too will be joining you for dinner this evening, and I look forward to seeing some of you then, exhausted, I hope, at the end of a day of furious argument and debate. Thank you very much.
So hello everyone and welcome. I think I know most of you, but for the avoidance of doubt, I'm Susie Frenkel. Welcome to our law school. We'll shortly turn to the keynote address of this morning, but before doing so, I'm going to introduce some further parts of the project. I'm delighted to see many of you in the audience who have participated in our project for the better part of 2 years, including the researchers. I'm also delighted to see people who have not participated in the project over the last 2 years. As has been said by Tony Smith and also Andrew Butler, we do intend for there to be a lot of discussion and debate. Every session that is in the conference has a considerable period of time dedicated to discussion and debate. So whilst there are many researchers in the room who will all have comments. We are, of course, welcoming new comments and discussion from the audience. To put some of the project in perspective and how we've framed the day-and-a-half conference program, I'll turn to the keynote session that we begin with this morning last. But the two sessions that follow that, firstly, there is a morning tea, and I'll turn to logistics. The morning tea and lunches will actually be in the common room, a student common room, which is really just to the left of this building, very easy to find, just across there. But at the morning tea, Sir Geoffrey Palmer will launch the book by the same name of the conference. Following that, we have the session Global Connectedness. I'll leave it till the session itself for the details of that to be discussed. But that session and the session after lunch, which focuses on the public voice and consumer interests, come from what we have called the stage 3 of the project, which is a detailed analysis of a number of issues that have led to the point we're at today. The papers that come from that stage are the papers that are launched in the book, and there are 15 different research streams. So on behalf of the whole project and all of the researchers, not all of whom are presenting today because we thought possibly a day and a half was enough of your time, thank you very much for those contributions. So those two sessions really set some of the framework of where we've started in this project and where we've come to. Out of the individual research streams in the project, we have constantly been following what we started calling the New Zealand questions. None of these questions are necessarily surprising, but what we have aimed as a team of researchers and commentators to do is to build some flesh and dialogue around things like, is New Zealand a bit special? Do we need to go it alone? How do we preserve our interests whilst globally connecting? And as many of our participants, particularly from government, have indicated, how do we resource all of that? And our participants from the community indicate, why don't you resource all of that? So that gives you a flavour, if you like, of some of the themes. Some of you will be aware that the last session today is our cross-cutting theme session, Crossing the Regulatory Divide. Again, I'll leave the substance of that session to when we get there, but the themes broadly that are discussed there include this notion that there might be features of uniqueness of New Zealand and what role they might play in regulation. What do we do about learning the way forward? How do we actually monitor, review and evaluate regulation, and how might we want to do it in the future? What does it mean if we're experimenting with regulation? And how do you deal with that age-old question of a bit of certainty, please, but some discretion to deal with on-the-spot matters? And because we have worked very closely and most enjoyably, but more on that later, with economists, we also have some specific analysis of the analytical techniques that can be brought to state-driven behaviour change. So those cross-cutting themes are ones that we have developed by the underlying work in the project. So that's why we begin by showcasing to you some of the underlying work in the project. Then, hopefully, we've had a lot of discussion and debate. Some of you are able to come to the conference dinner. Tomorrow, we turn to another keynote address where the focus there, again, I'll leave the details to there, but that's really to bring us back to questions of regulatory oversight. How do you deal with risk? How do you look at regulatory oversight? And the final session of the conference, or perhaps close to final session, is we present some details of what we call the regulatory toolkit. Again, the details will be in that session, but I want to draw to your attention, in your conference pack, there is a one-page handout, which looks like this. And this is a copy of the front of the regulatory toolkit, which ultimately will be online. I'm drawing it to your attention now because it's perhaps useful, although when you print it like this it appears small, but I assure you it's much easier to use online. It's perhaps useful to indicate that the whole project fits into what we're calling the toolkit and how we view the project through the lens of the toolkit. So for example, later we have a session on public voice and participation, and you can see that there's a link in this toolkit that takes you directly to points about that. So more about the toolkit later. It is our final output in a sense, so we get to it at the final part of the program, but I'm glad to point it out to you, and we may point it out to you in several sessions so that by the time we get to the toolkit session you're already au fait with what we're doing. So let me now turn to this morning's keynote address. When any scholar turns to study regulation, it's frequently true that they can come from, as we know in the project, a variety of disciplines, or indeed a variety of perspectives. Indeed, whether working in government, working in any discipline as a scholar, working as an individual, working as a consumer advocate, your approach to regulation often starts in very different places. In a sense, this is hardly surprising given the ambit of what is covered by the notion of regulation. We have in our own research team people who have made a career out of providing cost-benefit analysis as well as critiquing cost-benefit analysis and plenty of other sorts of analysis for government and, if I can use the term loosely, against government as well. We also have people in the team whose path to discussing regulation may come from their expertise either as constitutional public lawyers, human rights lawyers, trade law experts, in my own case as an intellectual property lawyer. What we all have in common is some questions about the frameworks of regulation that we've dealt with. So the expertise in the area is one thing, but the regulatory themes that we bring as a collective to this project are looking at commonalities and frameworks, commonalities and questions, and building towards these cross-cutting themes. Our keynote speaker this morning, Professor Haines, began her regulatory journey through her own discipline as a criminologist. Professor Haines has come to us from Melbourne University, where she is part of the School of Social and Political Sciences. Her published work includes looking at corporate regulation and the idea that maybe there's something beyond white-collar crime punishment and how to corporate regulation beyond punish or persuade. She's also done a considerable amount of research into globalisation and regulatory character. Her most recent book is the title of today's presentation, The Paradox of Regulation. So we come with a criminologist, and in fact we're very guilty in the project, although it's quite deliberate, of not having analysed criminology as an aspect of regulation at all. And I take this opportunity to add to my introduction and to explain why that is. How did we choose the areas of regulation? Well, we unashamedly say that we played to the talents and ambitions of the project. But before we begin, I want to thank and acknowledge that many of the researchers have gone beyond their initial areas of expertise to think, okay, we really have got to look at this topic, even if my life isn't dedicated to securities, investment, and so on. And there are a few examples like that. Returning to our keynote speaker, Professor Haines, as well as having a career as an academic, also has advised government, predominantly in Australia, in any numbers of areas of regulation and regulatory policies. There is a more full bio in your conference pack, which I invite you to turn to shortly. But without further ado, please do join me in welcoming Professor Fiona Haines.
I want to thank Susie very much indeed and the rest of the team for inviting me over here. As I was listening to the various preliminary introductions and welcomes, I thought, well, I'm neither a lawyer nor an economist. Not quite sure what I'm doing here. But I have been looking and studying and doing policy work in the area of regulation. I just counted for around 25 years. So I think I have something that might be of interest, hopefully, to you. And what I want to do today is to take you through the arguments in my book, The Paradox of Regulation, the same as the title of this presentation, to see if it can help you in your deliberations of how to essentially do regulation better. The book is designed around three different regulatory moments, three disasters. The first was an industrial disaster, the Longford gas explosion that happened in my home state of Victoria in 1998. The second was Australia's response to September the 11th and counter-terrorism, in particular the regulation of security at ports and airports. And the third was our largest corporate collapse, that of HIH Insurance in 2001. And looking at corporate law reforms and insurance law reforms after that particular collapse. Now, the reason I took three very different areas was to basically say, okay, well, hang on, wait a minute. To what extent do generic prescriptions assist, and where do generic prescriptions end in terms of helping us to understand how to do regulation better? I want to start, though, with where I started in my thinking, and that was, as a criminologist, I sort of often look at the inquiries and the incidents themselves, and a very common moment is what I call the never again moment. And the never again moment is when somebody, either in the media or politicians, say, this must never happen again. And I thought I'd take an example from your Pike River mining tragedy that occurred in 2010. One of the debates in Parliament, your Christopher Finlayson, the Acting Minister of Labour, saying the lessons from the Pike River tragedy must not be forgotten. New Zealand needs to take urgent legislative, structural and attitudinal changes if future tragedies are to be avoided. Government, industry and workers need to work together, and so on. So that this idea that regulation must come to the assistance and regulatory reform is needed at that moment where people sort of try and take stock and say, okay, where are we going to go from here? What are we going to do to make sure this doesn't happen again? And it's at that point that the pursuit of good regulation begins. Okay, let's get our minds together. Let's think how we're going to tackle this particular problem. The difficulties emerge almost immediately at that point. And the difficulties emerge around some key questions. An understanding of what good regulation actually means. How do you get good regulation in place? What are the processes and policies by which you try and achieve a good regulatory outcome? And what does it target? What is regulation there to do? What risk is it there to minimise? As soon as you start down this journey, things start to become somewhat complicated. In terms of good regulation, for some the answer is less. And this is one of my favourite quotes from our former Finance Minister, Lindsay Towner. I think you can still find it on a website somewhere. Like a smouldering fire, the Liberals let the deregulation agenda in this country lie dormant for most of their 11 years at office. I intend to reignite it. On the other hand, if you look through the discussions after the Pike River mine disaster, you see Darian Fenton from New Zealand Labour criticising Kate Wilkinson, saying she was a born-again deregulator, and that's an insult. You have Kevin Haig from the New Zealand Greens saying it's extremely clear it's the failure of regulatory regime of the government as a regulator. It's the failure of deregulation. So on the one hand, you need more, and on the other hand, you need less. Okay, yes, but who should do the regulating? Who is the regulator? Going back a bit in time to the 1980s, you can look at a statement by Alfred Kahn, who was responsible for the deregulation of the airlines in the United States in the 1970s and 80s, saying after the savings and loans crisis, this is not the time to fire the police force. And who's better for a quote than George W. Bush, saying, and even an imperfect market produces better results than arrogant experts and grasping bureaucrats. And then you have those in between trying to do the inevitable balancing act. In the case of Kevin Rudd failing, our former Australian Prime Minister, we also need a robust analysis of the social democratic approach to properly regulated markets and the proper role of the state. You go through all those debates, and you do, as I did in the beginning part of the book, and sort of say, well, you scratch your head and say, what is good regulation? For a number of people, good regulation is an oxymoron. You don't put those two words together. If you go to the regulatory reform bureaucracies, our own Office of Regulatory Reform in the Commonwealth of Australia, there's this perception that is light-handed, and it needs to be subjected to a survival of the fittest reform process. In other words, you make it jump multiple hoops because you need to use it very judiciously, and you need to make sure it's well targeted, and so on and so on and so on. This light-handed survival of the fittest approaches actually bears some resemblance to a number of the academics who have spent their lives studying regulation, such as John Braithwaite. However, the academic approach is quite different. It's different in one key area, and that is it is not light-handed. It is effective and tough-minded. According to advocates, it is flexible but just. So in other words, it has that flexibility evident in it, the same as the regulatory reform bureaucracies, but it is not light-handed. At the end of those kinds of debates and at that point, I think it's important to understand that regulation is partly scientific or technical or problem-solving. In other words, it does have a particular area of focus. But regulation is largely political. It's political in its designs, and it's political in its goals. So you've got this idea of regulation as being this kind of, in this political regime, this political context, and it's trying to do something. But what is it that is actually trying to do? Often, as I began, regulation is focused on an undesirable risk in the wake of adverse events. Explosions, fires, deaths, diseases, terrorist attacks, financial meltdown, global warming, whatever the particular catastrophe is at that point in time. And there's a perception that arises at this point, and that is, you know, Marie Antoinette, you can have your cake and eat it too. The idea is that regulation can go in a sort of a surgical way. I've said somewhat tongue-in-cheek at this point, like a surgical bombing raid to remove the risk whilst maintaining the reward. The idea is that you can have the economic activity, you can have the benefits, it can be business as usual except in this little bit, except in this little area that has to be removed because that is the undesirable risk that we want to get rid of. It was at this point in my thinking when I thought, what the hell's risk? Everybody talks risk, and risk and regulation and risk-based regulation and so on. And so I started on a journey going through the risk literature and so on. And it becomes very clear at this point that regulation sees itself as targeting a particular undesirable event or thing or activity or what have you. And I put this in a frame of reference of actuarial risk. So you're doing things like trying to understand the impact of what it is that you're trying to get rid of, its probability, It's understood as somewhat outside of the self. In other words, we don't want that thing to happen. We don't want that meltdown. We don't want that disaster. We don't want that pollution, right? So there's an understanding of that risk as somehow expendable to the common weal, somewhat outside. And this is the dominant form of risk, I would argue, in ideas around smart regulation. Smart regulation can get rid of actuarial risks. We don't need them. But if you look at the debates around regulation and you look at the influences on regulation, when people talk about risk, they often talk about it in very different ways. And people will say things like, that shouldn't happen, never again, we don't want that, we don't like that. And if you go to, there's a body of literature that sort of begins in anthropology and sociology and then moves forward from there, that talks about risk in very different terms. It talks about risk as basically designing the contours of our society, creating social norms that give us a sense of who we are and where we belong. So that in that form, risk is about who we are. So risk arises from within the collective. When people express these sorts of risks, they express concerns about their society and their identity. And make no mistake, when people express concerns, they're saying two things. One is, I belong. In other words, by expressing, I don't like that, they're saying both something about the society and something about themselves as belonging. This is my society, and we do things this particular way. The final probably will come as no surprise to you. Those people who are working in the area of regulation, and that is political risk. And this is not risks to us as a collective and not risk outside, as in something we want to get rid of. This is risk to political legitimacy. And this takes from another body of literature that I go into in the book. Essentially, political risk arises in two different ways, and these different ways are basically often at odds with one another. It's risk to political authority from keeping the economy going and making people feel safe. So in other words, what politicians and policymakers have to do is design regulations so that it allows the economy to keep going, but at the same time makes people feel safe, right? And these two elements are often in tension with one another. Now, I just want to say a quick word before I go into the case studies to try and make this a bit clearer. These three risks are equally as real as one another. You can't say that one is rational. People, there's a lot of people who like saying that, well, actuarial risk is the rational one. All the rest is irrational. It's emotional. We don't do that. We're sort of upstanding, intelligent people. Now, each of them, I would argue, is equally as real as the other. The consequences of each being raised to catastrophic levels is something that societies and individuals would do well to make sure never happens. But they're not kind of categorical in the sense that you can't put one, say, okay, well, that's an example of actuarial risk independent of political and socio-cultural. They're ideal-typical in the Weberian sense, for those of you who know your Weber, in that they sort of have an essential character that pushes and pulls the regulatory debate in different ways. But they have a different focal concern. One is out there, the actuarial. The second is us, who we are. And the third is protecting political legitimacy. They're real, but they're subject to a risk assessment. And the risk assessment process may be more or less accurate, and certainly very often is subject to systemic distortions. The importance, though, is that they shouldn't be conflated. They're both independent and need to be taken of and understood as independent, but they're also interdependent. In the research that I've done thus far, the dominant risk is political risk. Political risk often frames the response, shapes the perception of risk, And it does so in order to place the government as protector. And if you think about political risk is about keeping the economy going and making people feel safe. And in making people feel safe, you can reassure people in a socio-cultural sense that completely ignores the actuarial, right? So in that equation, actuarial risk, what started off to seem to be the thing that regulation was about, through the reform process is actually the most expendable. And I'll illustrate that point. The first I want to look at is the Longford gas explosion. Now, the gas explosion happened in the state of Victoria. The deaths were of 2 workers. One of the major issues, though, was that the state of Victoria lost gas for 2 weeks. And that really did get people's attention. So it was a big issue and it was a big political challenge for the state of Victoria. Some 5 years after, there was significant change, and I call it the regulator's nirvana. So in other words, there was a new regulatory regime designed. It was called the safety case model. And essentially, it was the regulation of self-regulation, sometimes called meta-regulation, sometimes called co-regulation, depends on the regulatory literature that you're looking at. Essentially, the sites themselves have to dig their own regulatory grave. In other words, they come up with the processes and procedures by which they will reduce the risk of a catastrophic explosion to the absolute minimum. That's then signed off by the regulator, and then they are judged according to that safety case that they have come up with. This safety case arose, though, in the failure of the initial response, which was industrial manslaughter. A law and order approach is often a first call by governments wanting to say how they're going to make sure it never happens again. For political reasons, the industrial manslaughter failed. At that point, the government threw up its hands and said, we've still got to do something, but we don't have a clue what it is. And that at that point, they brought in the experts and said, you solve the problem, we'll give you all the money and resources you need, and we'll leave you alone. I also went up to the Northern Territory and looked at their response. I wouldn't say their response was exemplary. I can answer questions if people are interested, but the risk was not that great. They had 2 major hazard facilities in that state, one a storage facility, the other a processing facility. And you'd say the risk was nowhere near as great as Victoria and New South Wales, that both have chemical plants and refineries within the greater metropolitan area, within metropolitan Sydney and within Victoria. You go up to New South Wales, though, there was no political risk attached to doing anything about major hazards regulation whatsoever. So when you looked at the regulatory reform process in New South Wales, it was tortuous. It took years and years and years and years. The debates in Parliament largely revolved around red tape and terrorism. At one point, there was an effective bill that was supposed to come before the House. That morning, a pit bull terrier bit a young child. That was pushed off the parliamentary agenda, and the pit bull dangerous dogs legislation, I forget the title of the legislation, it's in the book, that took precedence, and it was a number of years after that major hazards finally got a Guernsey. At that point, the next round of regulatory reform had occurred, or was in the process of occurring. There was little support for Regulator. The regulatory regime itself was divided between 2 agencies that didn't particularly get along. There was lots of committees, lots of problem solving, lots of careful thought, few resources, and little action. What about in the case of September the 11th? I've said in certain contexts that terrorism and counter-terrorism can work a bit like a political protection racket. And this was certainly the case in looking at the security of ports and airports, particularly some of the smaller ones. There was a heightened political tension around counter-terrorism and security, and that flowed directly down to the regulator's concern. And they would say, this is one of my favourite quotes, there's a constant need to amend the legislation and regulations. I mean, if the industry thinks it's bad complying with the regulations, try writing the damn stuff. Right? over and over and over again, sometimes responding to the minister, sometimes responding to what was on talkback radio that morning, sometimes responding to the mistakes that were put through in legislation only a week or so before. Reform after reform after reform after reform after reform. Multiple agencies. Whole of government approach, one might optimistically think. Well, difficult, different ministers. At the end of the day, says one, what's the public servant's aim? What's the minister's reaction going to be to this? And I guess I don't really care if my friends in tax or if the Treasurer says this is a crummy proposal or this is a ridiculous method of regulating this. I'm here to please the minister, and please the minister I will do. There was considerable resources put into counter-terrorism, security at ports and airports, and I'm not saying that all of it was wasted. I certainly don't think so. But money went in all directions, and some of it went, as one said, into building a new empire. So you had a new regulatory empire that was created, and the person I spoke to who was heading the empire at the point was somewhat wistful about how effective that had all really been. Finance. Well, this was a new area for me. And I had some trepidation, and it just got worse the more I found out. And part of my challenge in coming to the area of finance was to try and actually figure out what the hell the actuarial risk is here. And to try and distinguish reassurance and confidence from the actuarial risk, the risk of another financial collapse in of itself. And as I went through the processes, I came to understand that actually confidence and success are very closely related, but highly problematic, right? There's not for no reason that fraud is called a confidence trick on occasion. So the reform process itself is uniquely important in the area of financial regulation. The perception of reform and the usefulness of that reform to an extent drove success. The reform process itself was designed to reinstate trust and confidence, and the way it did so in corporate law reform was to draw on particular tropes that were seen as legitimate and good things to do: motherhood and apple pie, transparency, accountability, independent oversight, a little bit of punishment in terms of criminal liability of directors and so on. Now, when you went to the technical literature, each of those was critiqued, was subject to a considerable debate within the finance literature itself, but nonetheless they were taken up into reforms in order to engender confidence back in the marketplace itself. There was also an understanding of those designing the reform that regulators were only partially influential. So John Palmer, who was a Canadian prudential regulator, sort of did an investigation, a report on our regulator, APRA, and basically said, look, you've got a real problem here, because through superannuation and various other mechanisms, the pressures from shareholders for high returns and the pressures from financial markets for performance are overwhelmingly strong. So there's direct competition of the regulator itself, which shapes this particular regulatory area. So what happens is that actually disasters and corporate collapses can be quite good for regulators. It gives them an opportunity that they've been waiting for to get through a particular set of reforms that they think are going to be effective. But then after a period of time, there's pushback. And through some of the interviews that I did with our securities regulator, ASIC, there were comments like 3 years have passed as HIH, and now we're still in the process of trying to implement change, but the climate's changed, right? So this was about 2005 or something like that, you know, before the financial crisis, probably different now. But, you know, it was kind of like, hang on, wait a minute, you know, reform fatigue, we don't want any more of this. And what's more, we require a certain environment for our investors and investments, and we want regulatory security or regulatory certainty. Prudential regulation, I think for the sake of time, I probably won't go into it, is slightly different. In the case of the securities regulators, at least in Australia, see themselves as supporting market mechanisms. Prudential regulators see themselves as protecting the policyholder or the bank depositor. And that gives the flavour, and their political context makes it quite different. So in the prudential area, there was quite a degree of definancialisation that protected the policyholders in particular ways. Okay, so that gives you a flavour of the three reform areas. But regulatory reform, successful regulatory reform, is only the beginning point, right? Most of my work as a criminologist is looking at compliance, what actually happens on the ground. And you might have a fantastic set of regulations, but if people don't know they exist or misunderstand them or don't comply with them or whatever, or can't comply with them, you've got a problem. So the next thing I did was look at how the regulations, once they were designed, were actually implemented. And I'll just give you a flavour, and happy to answer questions. But what I found was that just as the three risks shaped the reform process, they also shaped the implementation process. In terms of socio-cultural risk, it was very evident that in terms of the major hazards legislation, it was a collective and social activity. And this is a quote from one of the people, one of the shop floor people who was responsible for dealing with the major hazards processes. Said, I'll sit in a meeting and the site manager would just go bang, bang, bang. He said, I had a bit of knowledge because I was part of the process and I could get a gist of what was being said, but sometimes I'd sit back and say, I don't understand a word you said. And you just bide your time, and it's obviously above what I need to know, so I'm not going to take any notice of it, right? The other thing is that people don't like displaying their ignorance. And showing up your own ignorance in terms of training or understanding is bad enough. What's really bad is if you show up somebody else's ignorance. And there was a safety officer who was passionate about major hazards, and he showed up somebody else's ignorance in a training session. It was one of the workers, and he was extremely unpopular, and he was always being in danger of being pushed out. Security. Security, you had this security juggernaut. It was not on paper very different to the safety case management regime. So in other words, each of the ports and airports had to come up with a set of regulatory requirements signed off by the regulator they then had to put in place. You've got a problem with terrorists, though. Terrorists think, right? So, in other words, you come up with the regulations, they want to get around them. That's what they do. That's how they're successful. So how do you design a regulatory regime around what you don't know? What you do is you design it around what you do know. You build up a narrative of what is going to make us secure, and it's based on what has just happened, not on what will happen, right? So you develop this narrative around how the attack will occur, but it's always unstable. Because of that instability, it is politically vulnerable and can keep on being changed. So in Australia, because there was bipartisan push for more security, it just kept on going up and up and up. Now, when you get down to the site level, this becomes impossible. And people know on the ground very clearly where the gaps are. So one of the issues was fencing. Fencing looks like it makes a place secure. You go to any security expert and they'll say, well, even the palisade fencing, the high security fencing will only stop people for about 10 minutes. You've got a bit of time, but not very long. Now, your main aim here is to keep the airlines flying and making people feel safe. So a lot of the things that happen in the security arena are around making people feel safe. What you don't see, maybe what comes to bite you. Now, I finished data analysis and collection in 2010. Something may have changed. But when you're on your passenger aircraft, there's a bunch of material that gets put in the hold just at the last moment. That's cargo. It's just-in-time cargo. Now, that's not screened. So when you're up there, as one of the people said to me, sipping your orange juice, most of the stuff in the hold of the plane hasn't been screened. How do you say? Now, this is a very profitable activity. Competition in the airlines are very high. Prices are going down. This material is often what keeps the airlines afloat, and getting that screened is a very difficult process indeed. And there's always patchly implementation. This is one of my favourite ones. A small airport built a nice brand new fence, and then people kept on forgetting their security code and their passes and so on. And so what they did was they cut a bit out of the fence. Just to make sure that the pilots with a small aircraft could get on and off, because they were getting pretty pissed off. They said, you know, we keep on, this is just useless. So they've left a spot where you can climb around and skirt around a piece of steel to get in, because otherwise you can't get in or off the airport. But these regulations were very powerful. Because of their political purchase, they were great, you know. So if you were an airport or a port manager and somebody came up to you and wanted to sticky beak around, you could basically say, get out, you haven't got security clearance. And so you had this very powerful regulatory vehicle that was used in all sorts of different ways to control people, with a very tangential relationship to security in of itself. Now, I think I'm running out of time with it. Okay. The last one is financial collapse. And, you know, I come from a family of business people, and I come from a family of accountants, but I'm not one. So I had to try and understand what the hell a set of accounts was. And I came to the conclusion that a set of accounts is basically a craft activity. A set of accounts is there to create an impression about the state a particular company finds itself in at any point in time. It is a moving feast. So it's trying to create a point in time from an ongoing situation, right? It has to both anticipate the future as well as deal with the past. So it's a complex social construction. As a result of some of the changes that came in, partly as a result of HIH, but also in terms of global changes, this is the changes to accounting standards, the Australian version of the International Financial Reporting Standards. What happened was that assets suddenly appeared. It looked like our assets went from 40 million to 180 million. Whoopee, aren't we? Good. We grew our business overnight by 130 million. How is that possible? On the other hand, there was an increased stringency in terms of the auditing and counting what the assets are that you actually have. One of the financial managers said 5% of our equipment in the stores are big ticket items worth about 80% of the cost. Yet the auditors were telling us you have to count everything. So we're counting these little washers, $1 each, 50 cents each, and we're going, this is crazy. So they just stopped doing it, right? Not worth our time. Then you have the past, present and future problem, the hedging. Right, so there was all sorts of hedging activities in some of the larger firms, particularly around the Australian dollar, which is appreciated in value and was stuffing up all the business projections. So they entered a few hedges. And then they would say things like, well, you're talking about 2 million or 20 million, fairly straightforward. We've got 100 million in this country. And then this was the phrase that they kept on saying, but it's only numbers. It's only numbers. And from that, then I understood that a set of financial accounts, in a sense, is a crafting of the numbers. I'm not saying it's malevolent. I'm not saying that it's unethical. But it's a process of crafting a set of accounts as an approximation of company value. A best guess, if you like. A considered opinion. But it may be more or less, have more or less relationship to what's going on. And anyway, confidence itself is essential in this process. If you lose confidence in a company, it doesn't matter what the damn figures say. They're stuffed, right? So there's a close connection in this area between actuarial and socio-cultural risk. So, what I argue in the book is that regulation is confronted with three different paradoxes. The first is the paradox of reform. And the reform paradox essentially is that you need to deal with all three risks in order to have successful reform: political, socio-cultural and actuarial. The master risk is political, and political is framed by keeping the economy going, so you listen to business, you modify your demands and so on, and you make people feel safe. You get the buy-in from your particular audiences for this particular reform. The temptation in a fraught political environment with very short-term thinking is to go for symbolic change, criminalisation, quick-fix solutions, and the use of policy-based evidence. You know, I know what I want to do, find me the evidence so I can do it, please. Or you deflect attention onto a different problem. If this one's really hard, you go for terrorists, asylum seekers, or pit bull terriers. They're easier to deal with than perhaps the problem you're confronted with. In that process, though, over time, it's the actuarial risk that is expendable. You cannot deal with the actuarial risk independently from the political and the socio-cultural. They come as a package. The second is the compliance paradox. Compliance also requires dealing with the three risks. So in other words, you want the reforms, you want the regulatory regime implemented in such a way that the particular hazard is front and centre of the particular activity or the particular workplace. Now, that's very difficult to achieve. You have to do so in the context of engendering respect for co-workers, managers and so on, addressing those socio-cultural concerns, and it needs to be attuned to a sense of order within the workplace itself. There is also a version of political risk, and this is basically the legitimacy risks of business. I've written a separate paper on this particular aspect. So a business itself will implement regulations with a weather eye on their profitability and reassurance. So that's the same, keeping the economy going, keeping the profits coming in, reassurance, everything's okay. And reassurance may be of the market, of stakeholders, of workers, of regulators, but it doesn't necessarily mean that you're dealing with the actual hazard at hand. In terms of the actuarially based, the agency-based actuarial risks, I came to the conclusion that counterterrorism and finance share something in common. You have financial terrorists and you have real terrorists on the ground. Both are trying to find a way around the regulations in order to get where they want to go, right? Now, in terms of actuarial-based or agency-based actuarial risk, confidence is a critical part of the equation. Confidence of the travellers. One of the major impacts of September the 11th was the collapse of, I think, 12 or 13 airlines in the United States. They needed to get those airlines back in place. We had the collapse of Ansett in Australia. So the compliance measures need to reassure, but again, reassurance doesn't necessarily mean that they're effective. There are multiple regulations that are attached to any workplace. Some of them will gain a priority more than others, and some of them will be used in ways that the regulators never intended. The final paradox is the paradox that's inherent within a regulatory strategy in of itself. I call this the limits of instrumentalism. Actuarial risks are the problem that regulators are asked to solve. You have a particular risk you want to get rid of. You have a particular hazard you want to get rid of. And what happens is that then you say, okay, we've got to narrow it, we've got to define it, we've got to make sure our problem is carefully defined. We have to do a cost-benefit analysis. In Australia, you need to do a cost-to-competition, a competition analysis. You keep sharpening it, refining it down, and so on and so on and so on. This can be powerful and it can be effective, right? I'm not somebody who's against the regulatory process. But that process of narrowing and defining is problematic in the sense that it can generate a tick and flick kind of response. You make it easy to comply with, so people stop thinking about it, they just tick the boxes. The other thing is, the tax accountant problem. You come up with a definition of paying a fair share of tax, and you have an whole industry around there saying, oh, how does that mean we can pay less tax, right? So you have that gaming kind of response. The solution often is to move to performance standards. You broaden. You say you have a duty of care. You need to attend to the substance of this particular regulatory regime. What that does is make it more complicated, make it more difficult to comply. Then you get the red or green tape pushback. This is too hard. There's too much red tape, there's too much green tape, go away and think again. But you keep coming back to regulation because regulation promises a lot. Unfortunately, sometimes it delivers less than it promises, and sometimes it is institutional change that may be needed rather than a regulatory reform. So in conclusion then, what I've argued is that regulation can be critical to the reduction of risk, but it's a complex process involving 3, not 1 risk type. You can get so far in generic prescriptions, and I think the regulatory literature gives many examples of how you might do this better. But ultimately, successful regulation requires an understanding of content, what it is you're trying to do with this particular regime, context, economic and political context. And without those, the generic prescriptions have their limitations. Then finally, as I've said before, I think there are occasions where regulation can promise more than it can deliver, a bit like a surgical bombing raid that glosses over the need for wider-ranging reform. Thanks very much.